Yes, good. Good afternoon. We will now reconvene today's regular council meeting. We are rising from closed session with a report, and the report is as follows. The council declared the northerly portion of the property of 920 Larmer Line as outlined in part one being 0.36 hectares or 0.89 acres as surplus as per the disposition of land bylaw number 2016-07. And the council directs staff to sell part one to the property to Hydro One Network for the future Hydro One substation for the total compensation of $148,000. And moving a seconder for that report, moved by Councilor Burns, second by Deputy Mayor Huntley. All in favor? That is approved. And in relation to that report, there's an additional motion for council consideration that council direct the budget committee to utilize the net proceeds from the sale of this property to reduce the 2026 tax levy and that the utilization be reflected at the next special budget meeting in January. Moved by Councilor Knappschaft, seconded by Councilor Byrne. All in favor? That motion is also approved. Thank you, council. Next, we need a motion. We are at 8.1, so we need a resolution to open the public meeting today. Moved by Councilor Knappschaft, second by Councilor Byrne. All in favor? That is approved. Now we have two reports. So Matt, you'll start with, we have first the 402 Thorn Drive report. Thank you.
Thank you. Good afternoon, and through you, Mr. Mayor, to members of council and the public. Before you today is planning report number 2025-50. The report presents two recommendations. One, the council receive and consider all public comments received on today's meeting. And two, that bylaw number 2025-60 be approved to rezone a portion of the property to prohibit residential uses and recognize the reduced lot area because of a severance of a surplus farm dwelling. On October 30th, 2025, Peterborough County Land Division granted the owner of 402 Thorn Drive a conditional approval for severance application B-74-25. The proposed rezoning amendment discussed today is to fulfill one of these conditions. The land subject to the zoning bylaw amendment are approximately 38 hectares or 94 acres in size, with 180 meters, 590 feet of frontage on Zion Line. The property is currently developed with a single detached dwelling and agricultural structures. The rest is an active farm parcel. The severed lot is just over 2 acres in size and will include a dwelling and 2 outbuildings. Just this morning, staff received an updated reference plan showing that the parcel is now 5 meters closer or over to the west. This wouldn't show up on the scale, but the zoning still meets the requirements of the parcel. Typically, severing the agricultural properties is prohibited by provincial and township policies. However, severing a surplus farm dwelling from an active agricultural property can be permitted. A surplus farm residence refers to an existing habitable detached dwelling, including any associated additional residential units that are rendered surplus as a result of farm consolidation. So what happens if a farmer owns 2 active farm parcels? They only need 1 house, and so policies allow you to you can sever off one of those houses from the agricultural properties, provided that it's the 2 active farm parcels and then consolidated together on title. So these farm parcels will be consolidated with another parcel on Carmel Line. Therefore, the severance application conforms to the township policies. The purpose and effect of ZBA 08-25 is to rezone the agricultural zone to the agricultural exception 24 zone to prohibit residential uses and recognize the reduced minimum lot area and clarify the determination of lot frontage and area. 2, to rezone the natural linkage zone to the natural linkage exception 3 zone to prohibit residential uses. And 3, rezone the portion of the Oak Ridges Marine Countryside zone to the Oak Ridges Marine Countryside exception 7 zone to prohibit residential uses. The Oak Ridges Marine Countryside zone area will not change. Copy of the draft bylaw was provided as part of the report. Notice of the proposed amendment and public meeting was circulated by first-class prepaid mail to all assessed persons within 120 meters or 400 feet of the subject lands, to all required ministries, agencies, and township directors. Notice of the public meeting was posted on the township website, and a notice sign was posted on the Dial Line, the Thorn Drive, and the Zion Line frontages of the property. Therefore, this notice complies with the requirements of the Planning Act. To date, townships have received 1 phone call from the public They were seeking clarification of the property. They weren't for or against it. They were clarifying what the application was for. After the drafting of the report, staff received comment from the Kawartha District School Board, who have no objection to the report, to the application. Enbridge Gas has no objection to the application. Township Fire, Building, and Public Works Department do not have any objection to the application. And approval of the entrance permit off Dial line is pending final inspection from Township Public Works. And Autonomy Conservation has no objection to the application, and a permit from that agency is not required. Therefore, the proposed amendments are consistent with applicable policy and regulations. Thank you.
Great, thank you, Matt. Members of council, questions with regards to the report? Council Byrne.
Through the chair to Matt, just for my clarifications, the fact that this parcel of land partially in the Oak Ridge and Moraine, but a portion of it's not, is what makes this a doable thing.
Through the chair to Councillor Byrne, the portion of the property on the Oak Ridges Moraine, so typically we don't have severances on the Oak Ridges Moraine, but section 32 of the Oak Ridges Moraine Conservation Plan does permit lot creation for a surplus farm dwelling. So that is sort of the nuance to this one, why it's different from any others. Thank you.
Councillor Nacho.
Thank you, through you, Chair. Matt, you referenced Carmel Line. Could you just explain to me what that meant? Because I didn't see it in the report, but you did orally mention it. So it's part of another farm?
Through the chair to the councillor, yes, the owner owns at least 2 farm parcels. And so this one will be consolidated with another farm that he owns. So the house portion will get severed off and sold to somebody else. And the active farm parcel will then get consolidated with his active farm on Carmel Line.
Follow up.
I happen to live across the street from that, and my only concern, and I'm not against any of this happening, it's just that I'm looking where the driveway's coming out and it's right at the top of the hill. So from a visibility standpoint, pulling out, I just was kind of I was just kind of like surprised that they would have had it right there instead of having it somewhere either further down the hill or further up the hill. So just to voice my concern.
Through the chair of the councillor, yes, Public Works has reviewed the entrance permit and they have approved it pending final inspection. So, thank you.
Other questions? Seeing none. Okay, thanks, Matt. Thanks for a great explanation in the report as well. I thought it was very well done. Now we're going to open questions from members of the public wishing to speak to the application. And just for clarity, so just so everyone understands the purpose for the public meeting. So microphone's there. You can see mine's lit up now, so I get to speak. So you have to press the button. I have to unpress mine and then you'll press yours to move forward. And just just to mention as well, like we'd like make sure that the commentary being received tonight, so we need your name and address, and then you can provide your comments so that it can be added to the formal record as well for the purposes of the meeting. But just keep all commentary to the planning related issues at discussion today. So that's just some feedback. So any members of the public wishing to speak towards the 420 Thorn Drive application, you're free to come to the microphone. Going once, going twice, seeing none. Very well, then we'll close, or sorry, we need a resolution to close that portion of the public. Oh, sorry, excuse me. We need questions or comments from members of the public, so we need consideration of the report before we close the public meeting. Consideration of the report. Anyone like to make a motion with regards to the 2 recommendations? Moved by Councillor Byrne, seconded by Councillor Natchoff. Almost gave you a promotion. All those in favor? That is approved. Correct, you're right. Perfect. That portion is complete. Moving on to 8.6, report planning 2025-51, 401 Elgar Drive. Ms. Ellis.
Thank you, Mayor Grimm. To members of council, members of the public and staff. Planning report 2025-51 is before you today regarding a zoning bylaw amendment application for an existing lot of record located at 401 Elgar Drive. An application was made to the township for a zoning bylaw amendment for the subject lands. Mark, could you please go to the key map so everyone knows what property we are talking about? It is attachment number 1, I believe. The property itself is located in part of lots 8 and 9, concession 2 of the Cavan, the former township of Cavan. The application has been filed to permit a second single detached dwelling on the property for the purpose of temporary accommodation. Supporting documentation that was supplied with the application included a planning justification report prepared by Clark Consulting Services and a topographical illustration prepared by Elliott and Parr. The property itself is about 65.9 hectares or 163 acres in size, and there is public road frontage on Carmel Line and access to the property from the end of Elgar Drive. According to the application submission, the site is currently developed with a single detached dwelling, a garage, a barn with residential units, a cottage, and a swimming pool. The house was built more than 50 years ago. The date of construction of the garage and cabin are unknown, and the barn with the residential units was renovated 2 years ago. The zoning bylaw amendment itself is required to legally recognize the renovated barn/hangar on the property as a second single detached dwelling. The property is currently zoned the Oak Ridges Marine Core Zone and the Oak Ridges Marine Environmental Zone. The property is also subject to the Oak Ridges Marine Environmental Plan Review Overlay. The zoning bylaw amendment being considered by council today does affect lands within the Oak Ridges Marine Core Zone only. So the majority of the property is not subject to this zoning bylaw amendment. If I could ask you to flip to Schedule A of the draft bylaw, Mark, I'd appreciate that. And it will show members of the public. Keep going. It's the map with the bylaw. Oh, that's the one right there. So the area that's hatched is the area that's actually subject to the zoning bylaw amendment before council today. So this portion of the property that's hatched is proposed to be rezoned from the Oak Ridges Marine Core Zone to the Oak Ridges Marine Core Exception 1 Zone. The Oak Ridges Marine Core Exception 1 Zone will permit a second single detached dwelling on the property for the purposes of temporary accommodation. Temporary accommodation is defined as housing for short-term stays for any purpose ranging from a few days to several months. As proposed, temporary accommodation will be limited to the single detached renovated barn existing as of the date of issuance of an occupancy permit under the Ontario Building Code. Those definitions are included in the draft amendment. All other standard relevant provisions of bylaw number 2018-58 as amended will apply. And just for members of the public, bylaw number 2018-58 is the comprehensive zoning bylaw for the township of Cavan-Monaghan. Notice of this application was provided as per the requirements of the Planning Act. So notices were sent out to all assessed persons within 120 meters of the subject property. We circulated to all required ministries and agencies, all township departments, and signs were posted on both frontages of the property. As of the date when the report before council was drafted, we had received comments from Enbridge Gas, who had no objection to the application. We had received comments from the building department, who have indicated that the main issue is the concept of the barn being an established existing use. The township records show the use being a barn only. Any change of use was never legalized. There is no record of lodging for crew or bedrooms of any sort. Secondly, the position regarding the repair or renovation of the barn is not correct. It's a demolition of a barn and construction of a new single detached dwelling. If there were structural concerns with the building, the concerns should have been rectified through building permits. Thirdly, no building permits were applied for prior to construction of the new single detached dwelling. A building permit for the dwelling will be required should the zoning bylaw amendment be approved. The fire department supports the building department comments, and the Township Public Works Department has no objection to the application. After the report was drafted and filed with the Clerk's Department, we have received additional comments from a number of agencies and members of the public. Autonomy Conservation has provided written comment that the application is consistent with Chapter 5 of the PPS, or the Provincial Planning Statement, regarding natural hazards. The proposed development will not create new or is not proposing to aggravate existing hazards. Permits are not required for the proposed recognition of a second dwelling temporary accommodation use. The subject property is not in a vulnerable area and source protection policies do not apply. The proposed development is not subject to review by the Risk Management Official Office, and a restricted land use notice is not required. Finally, the Kawartha Pine Ridge District School Board has not identified any issues or concerns related to their mandate. So those are the agency comments. Public comments we received by email included the first one from Barbara Walker at 1417 Zion Line. She has indicated that the application will contravene and undermine the Oak Ridges Marine Conservation Plan. Area residents can confirm the historic use of the hangar pre-2001 and in subsequent years did not include the temporary accommodation for workers. The application is not justified. Brad Marco provided comment by email. I'm sorry, I don't have an address for Brad, but he's indicated that activities on site appear to have the potential to negatively affect the natural heritage features, hydrological features, and ecological integrity of the Oak Ridges Moraine. Given the environmental significance of the moraine, he requests that the township investigate activities to determine if they comply with provincial and municipal regulations. Thirdly, Barb Heidenreich of 180 Second Line Baileyboro has requested that council not adopt the zoning bylaw amendment. The application is contrary and undermines the intent of the Oak Ridges Marine Conservation Plan as it applies to development in natural core areas. As a long-term resident of Cabin, she confirms that the hangar in the past never included temporary accommodation for workers, so any request to continue using the building as a second dwelling for temporary accommodation is not justified. Regarding those that conduct bylaw infractions is a principle Rewarding those, that conduct bylaw infractions is a principle that should not be accepted by any council. Jane Wilson of 700 Carmel Line has indicated that in the Oak Ridges Marine Conservation Plan, a second dwelling is not permitted in the natural core area. The hangar was not used for temporary lodging, only as a hangar and storage area. Residents familiar with the property and the hangar know that no one ever lived there. She requests that council not adopt the zoning bylaw amendment. John Culver of 9 Sowden Lane has requested that council not adopt the zoning bylaw amendment. He indicates it will contravene and undermine the Oak Ridges Marine Conservation Plan as it applies to development in the natural core areas. The hangar did not include temporary accommodation for workers. The request is not justified. Work done on site is a breach of the township's building bylaw, building code act, and township zoning bylaw. There's nothing to support the application. Jane Zednick of Campbellcroft has indicated that the building that is subject to the application is being used as a luxury residence rental. It is advertised as a perfect spot for weddings or corporate events with amenities. Under the Oak Ridges Marine Conservation Plan, post-November 2001, a new second dwelling is not permitted in the natural core area of the Oak Ridges Moraine. The hangar was not used for temporary lodgings, only as a hangar and storage area. Residents familiar with the property and the hangar know that no one ever lived there, even temporarily. Evidence was provided in 2024. If some of you remember, we processed official plan and zoning bylaw amendments at that time. With regard to previous application that demonstrated the site of a luxury residence was never the former site of a barn. The photo from the late 1950s, early 1960s showed a drive shed that became the site of the hangar. The barn was in a different location. Being in poor condition, the barn was demolished by the owners in the late 1980s. The luxury residence is in the same location as the drive shed in the historic photo. The former barn was demolished and replaced with the guest cottage. The applicant has not provided any evidence, including the planning justification report, that the hangar was used to temporarily house an airplane crew. The PGR provides unverified claims. The applicant may be unaware of the restrictions, conditions that apply to natural core areas or ignored them. Request is not justified or supported by the evidence. The adoption of the bylaw will set a dangerous precedent. Celia and Doug Hunter from 581 Elgar Drive have indicated that they trust that the municipality is aware of and reacting to the situation, which is in contravention of restrictions for development on the Oak Ridges Moraine. They've asked, how did this progress to this stage? They've also indicated that threats from the property owner via legal counsel prevent them from publicly voicing an objection, so they turn to elected officials and municipal staff to uphold all related legislation. Eva, I'm sorry, Eva, if I don't pronounce your name right. Eva Bakovsky of 686 Carmel Line has provided written comments that request that council not adopt the proposed zoning bylaw amendment. It will contravene and undermine the Oak Ridges Marine Conservation Plan as it applies to development in designated natural core areas. The historic use of the hangar barn pre-2001 and in subsequent years did not include temporary accommodations for workers. So the request to continue this building as a second dwelling for temporary accommodation is not justified. Adoption of the bylaw will set a dangerous precedent. The Oak Ridges Marine Conservation Plan explicitly prohibits new secondary or additional dwelling units in natural core and natural linkage areas. There were 2 residences on the site before 2001, the old farmhouse converted to the main residence and a heritage building converted to a guest cottage. The luxury rental residence was not constructed on the same footprint as the hangar, which had a footprint of approximately 30 by 40 feet, a hangar that was never used to provide temporary accommodations. The planning justification report provides no citations or proof that second residences within the natural core area of the Oak Ridges Marine have been recently approved and under what circumstances. There is no evidence that this has already happened in Cabin Monaghan. Approval of the bylaw will set a dangerous precedent. The submission from Eva includes quoted information from George Rapp, Jane Zednick, Joe and Muriel Wiseman, Annette Follis, Alice and Bobby Tamo, Glenn Follis, Jill Williams, and Arnaud Bratt. All of these people indicated via email to Ms. Bykowski that the hangar never included residential space. The space was storage for the plane and general storage. The airplane was maintained at Buttonville Airport. The hangar was not habitable. The Cessna airplane was sold in 2001. A glider was stored at that location until 2010. At that time, the hangar was used as a garden tool shed and for storing landscaping equipment until 2017. Joe and Muriel Wiseman submitted comments that they knew the previous owners, and I'm sorry, I don't have an address for them as well. They knew the previous owners of 401 Elgar Drive well. There was never anyone else living on the property. They were extremely private and ecologically conscientious landowners. They request that council not adopt the zoning bylaw amendment. The use of the hangar pre-2001 and subsequent years did not include temporary accommodations for workers, so the use is not justified. In addition to the public comments we received and the ministry and agency comments, staff reviewed this application relative to the Oak Ridges Marine Conservation Plan, the Provincial Planning Statement 2024, the County of Peterborough Official Plan, and the Township's Official Plan. In the Oak Ridges Marine Conservation Plan, existing means lawfully in existence on November 15th of 2001, and for greater certainty does not include a use, building, or structure that is in existence on that date without being lawful. In staff's opinion, no evidence has been provided by the applicant to confirm the existence of a residential use of the building as of November 15th, 2001. No information has been provided to indicate how the temporary accommodation use meets the definition of existing in the Oak Ridges Marine Conservation Plan. The township has no record of a residential use in the building as of November 15th, 2001, and believe me, we have looked. The regulations in the draft bylaw do make enforcement difficult and challenging for staff. How do staff regulate that the occupants have permanent accommodation elsewhere, and or how long the guests are staying on site? The application is, in our opinion, not consistent with the PPS 2024 and does not conform to the Oak Ridges Marine Conservation Plan and the county and township official plans. A detached second dwelling is not permitted in the natural core area of the Oak Ridges Moraine. Having said all that, the recommendations in the report before council today include that council review and consider all verbal and written comments received at the public meeting, that council not support the approval of the zoning bylaw amendment because it does not conform to the Oak Ridges Marine Conservation Plan, the county official plan, and the township official plan, and lastly, I would just like to leave with council that should you wish to entertain the zoning bylaw amendment for the property to permit the second dwelling, staff recommend that the draft bylaw be revised to better regulate the use.
Thank you, Ms. Ellis, for the summation of the report. Questions with regards to the report, members of council? Deputy Mayor.
Through you, Chair, to Ms. Ellison. There's a lot going on here with this report and the history of this property. I'm just trying to wrap my head around. Is by changing the zoning, is that trying to legitimize the building itself? But that still isn't going to address any of the permitting issues that the building has experienced. Is that a fair assessment?
Through you, Mayor Graham, to Deputy Mayor Huntley and members of council. So the zoning bylaw amendment is required to legally recognize the second residential use on the property. And the way the bylaw is drafted, we're recognizing it because the applicants have indicated it was a legal use as of 2001. The zoning bylaw amendment needs to be approved because it's applicable law before any building permit can be issued through the building department. So the zoning bylaw amendment does affect the ability of the building department to issue permits.
Thank you, Karen. Other questions? Counselor Nacho?
Thank you, through you, Chair. Ms. Ellis, you had mentioned in one of the complaints that were issued by one of the local residents, I think it was Celia Hunter, that there was like a threat of legal action. Could you just read that back to me just so that I'm aware of what it is that she had spoken?
Through you, Mayor Graham. So I'm sorry, I don't have the legal letter in front of me. I just have a summary of comments. So they've indicated that threats from the property owner via legal counsel prevent them from publicly voicing an objection. So they turn to elected officials and municipal staff to uphold all related legislation.
Other questions? Seeing none. So we are now going to open for public comments with regards to the application. So same story as before. Follow the light. There's a button here on your right-hand side. And again, just reserve all your comments. We're going to maintain an orderly meeting. So just speak to the application, state your name and address as you come to the microphone. So the microphone's up. Receive it by all means. Yeah, sorry, Bob, before you go, just, I believe there might be one or two attendees that are online. So if you are online in a waiting room or in the background, if you just use the raise your hand feature, then the clerk and the deputy clerk will make sure that they recognize you in sequence as well. So over to you, Bob.
Thank you. I apologize for the mask, but I've been fighting off cold and we learned today that one of our staff had COVID. So I want to be careful that I don't infect anybody else. Not that I've done that from anybody initially, but that's the purpose of the mask. Thank you for the opportunity to address particularly the staff comments. The purpose of the zoning bylaw amendment, at least from our point of view, is to recognize the existing use of the barn/hangar for the temporary accommodation, the property, which has existed prior to 2001. Staff described the existing and proposed use as regulating a residence, but our intention was not to require a second residence, but rather to allow the use of the barn as temporary occupancy, which was established prior to the critical date of November 15th, 2021. I do acknowledge that we've been unable to get definitive information on that, but our client established that when he received the barn, that it was converted into an aircraft hangar and the storage of aircraft, and it was necessary at that time, and that was prior to 2021. It was necessary at that time for mechanics to live on the property, to at least be there overnight. So there was an establishment of temporary accommodation with the aircraft hangar, and we understand that that's when the temporary accommodation was established, and that was 25 or more years ago. It thus requires the temporary accommodation, and it's without a residential use. The facilities required for such temporary accommodation were present when our client took occupancy of the property, and he has, as he indicated, it was in a state of disrepair and he wanted to repair the structure. He was advised that there was necessary permits, and he got permits to do that, so that he has renovated the property, and that includes provisions for the temporary accommodation, which includes a well and septic tank, and the facilities were there in a state of disrepair for people to live overnight temporarily, to be accommodated there. Our initial application was for an official plan amendment where we intended to address the staff opinion that the use required the approval of a second residence on the property. And I understand that that continues to be their requirement, but I want to be clear that that is not our intention. Our client does not need a second residence on the property. The intention is strictly to recognize the temporary accommodation that was in our opinion, there. And I do apologize that we have been unable to get a definitive opinion on the temporary accommodation, but because of the nature of the use of the property and because of the facilities that are already there or were already there, it's our opinion that the temporary accommodation was and is an existing use. With respect to the Oak Ridges Moraine, it's not the intention of our owner of our applicant, our client, to make any adjustments. The building itself, the profile of the building, the floor plate of the building has not changed. And so there are no changes anticipated as a result of this construction to accommodate the temporary accommodation. We believe that the temporary accommodation can be qualified and permitted as an agritourism use. That's its purpose, to allow people to experience an agricultural property. And that would be what the purpose of this zoning application is. And again, despite our inability to provide proof of the early existence, it's my opinion that the approval of zoning bylaw does recognize an earlier use in the temporary accommodation that's supported by the presence of the facilities in the barn and in the alternative, the establishment of a temporary accommodation can be permitted as it complies, in my opinion, with the Oak Ridges Moraine, the county, and the municipal official plan as an agricultural related use. On this basis, we believe that the approval of the zoning bylaw amendment to permit the temporary accommodation without the residence represents good planning and will complement and add to the maintenance of the agricultural use on the property. Thank you for the opportunity to present that. Nope.
And Bob, just confirming you're representing Clark Consulting Services and the proponent, just for the record for Cindy, right? Just, yeah, perfect. No problem. We got you. Perfect. Thank you for those comments. The podium is open for anyone else wishing to come forward. Sure.
Okay, got it. Hi, my name is Jane Zednek. I live at 4129 10th Line, Campbellcroft. This is a really disturbing application. It is disturbing that the subject of this application for a bylaw amendment, a 5,000 square foot residence advertised as a luxury rental, was constructed without permits, noted in a 2024 staff report, and in non-compliance with conditions set in the Oak Ridges Marine Conservation Plan as they apply to natural core areas. It is disturbing that this is the second unsubstantiated attempt to somehow justify that this residence complies with the Oak Ridges Marine Conservation Plan when historical documentation and community knowledge does not support this application or the previous 2024 application. You just heard through Ms. Alice, testimonies from numerous residents that knew the former owners, that there was never accommodation at the supposed hangar, which was never a barn because the barn was actually in a different location. And the most disturbing is the fact that threatening letters had been sent by the applicant warning not only specific residents, but any person to not attend this public meeting, stating in the letter that you and your allies refrain from attending or otherwise commenting on the next council meeting, which is outrageous. A municipal public meeting, by definition, in the Planning Act, is a gathering open to the general public for discussing issues, exchanging information, and providing input on matters of public concern, of which this is. That's my comment.
Thank you, Ms. Edmond. Anyone else wish to speak? Come forward. Just again, name and address, please.
Hey, good afternoon. My name is Robert Brown. I am MES, PhD, ABD. I'm the chair and executive director for Save the Oak Ridges Moraine Coalition. Our corporate address is 45 Crows Pass, Port Perry, Ontario. for those of you that don't know, Storm Coalition has been around since 1990. For those of you that don't know our work, we are the organization that brought both the plan and act into effect. We participated with the province on the creation of the plan, on the negotiation of the plan, on the recommendations and the development of that. That is our major victory. Now and in current state, we now come out to municipality meetings like this and offer support, interpretation, and try to guide the protection of the moraine going forward. After the enactment of the ORMCP, and since I think April 2022, there's been up until April 2022, there's been relative certainty about how the plan is supposed to be interpreted when you're reviewing development applications on the moraine and greenbelt lands. Unfortunately, I think since 2018, there's been a conservative shift in attitudes. There's been a loss of knowledge. We don't have organizations like the Moraine Foundation that are offering kind of training support, municipalities, and in times the ministry has been silent when you're trying to interpret these kind of cases. What we have been doing over the past year is, and I thank you for your diligence, you're one of the few municipalities that has all of your agendas and minute meetings up since the last Greenbelt review in 2015. So we have been able to go back and go through all the municipal documents in this municipality and the other Oak Ridges Moraine files to understand where and how land use planning changes have been made. We've also done the same thing with policy reports, with OMB, OLT rulings. We've compiled a massive database to understand how decisions are being made, the way they're being interpreted, and try to enforce those decisions. I'm relieved that I'm here today to support the decision provided by your planning department. It's our opinion that staff have correctly interpreted the ORMCP, and we're here to provide additional context and to ensure the plan and act are being applied to the full extent of the law. Over the last year, I was explaining to you what we've been doing, and through those kind of reviews, we've been able to analyze and see different places where applicants are trying to bend the Oak Ridges Moraine or work around the Oak Ridges Moraine, whether intentionally or unintentionally. And I think this file that's before you right now shows at least 3, if not 4 cases where we've seen this happen elsewhere and we're concerned by it. So the first one is the existing use claim without documentary proof. It states in the planning statement and in the ORMCP that there are legal pathways to establish this proof. What you've been offered here is not one of those legal pathways. 2, what we see is strategic deferral, places where that the burden of evidentiary documentary is being pushed down the planning chain and not being offered at time of decision. Your planning staff has, I think, correctly interpreted that, and they're requiring that evidentiary proof now before the decision is made. 3rd, we've seen function creep, or what I would say commercial creep into protected designations. So this is where unpermitted or quasi-commercial residential footprints are formed into like minery or temporary kind of uses within natural core linkage areas. We see it in a variety of ways, like trying to sell agricultural uses that are actually commercial or recreational uses that are actually commercial. It's a way of upgrading the permitting, and they've kind of bend the rules around it. The 4th one, and I would say now, after hearing the statement from the planner, is that there is clear categorizations between agricultural uses and recreational uses. Agricultural uses are not recreational, recreational are not agricultural. If the pre-existing use was agricultural, it was not recreational. So I would say that this application presents a bunch of these hallmarks, an inserted pre-existing dwelling without an evidentiary dossier that tribunals and courts demand, a reliance on flexible phrases, I kind of like no numeric or locational tests, a program that intensifies accommodation on top of, natural core permissions. There's, as I think the counselor was right to point out, there's a very complicated set of issues here that need to be parsed out. And I think just as importantly, I think the file confirms that you need to have process discipline when you're dealing with them. And that is the approach your staff has taken. where other municipalities have experimented with kind of ad hoc administrative gates or allowed approvals to proceed on assurances that studies will follow, you're asking for these records up front. So I think that, well, I'm not a lawyer and I am not offering legal advice. I think you will also find that the points made by your planning department are supported by OMB and OLT case history. I think you'll find in cases like Stanek versus Aurora, the tribunal disciplined parties, that full expert record had to be present at time, that it could not be backfilled later on. I think you'll see in cases like de Blasi versus York that pre-existing gates were narrow and that you had to provide that documentary proof. There's kind of a bunch of them that go on here, that you should be aligned with scope control. Bushland Heights versus King, tribunals attempted to tuck an ORMC conformity route inside zoning or administration without providing lawful instruments. There's a list of these that go on. It's in the last 15 years, there's probably about 8 or 9 OLT, OMB cases that could be brought up that would be supporting the decisions that have been put forward by your staff. I know that today you're not here undertaking a discussion about enforcement. It's not the subject of today's discussion. But I believe that it would be in the best interests of the municipality to set a strong example that deters further commercial creep and the exploitation of diversified agricultural uses. The end goal, I think, should be the full and complete restoration of the site. I'll thank you for your time. If there's any questions, I'll be happy to answer them.
Thank you, Robert, for those comments. Other proponents wishing to speak, just come forward. Going once, go ahead, Mr. Brown.
Your Honor, Mayor and council members, I am once again presenting our request with respect to 401 Elgar. Our previous presentation was miscast due to confusion as to what we were trying to accomplish for the property. As such, the conversation, which included the public, was marred by the public's misrepresentation and lack of clear focus. For my involvement in that, I will apologize at this time. We are here in front of council to ask for my family's continued use of the barn structure. We have presented to planning certain facts that I'd like to go over with council so they have a clear understanding of the situation. My family bought this property with all the buildings in place in 2017. Essentially, we have been owners and your neighbors for 9 years. We did renovations over 2017 and 2018 years. In 2022, we were approached by planning staff, and this started a 4-year back and forth with the township. It was our legal opinion that we did not actually need any permits to fix up the property, as we were told by our lawyers that the property was permitted properly. There were no comments from the township on any issues. There were no liens. There was nothing from the township. The township never informed our lawyers that, in fact, they had no information at all on the property due to the loss of all archival information. This lack of information forms the basis of the problem because it is our opinion that, firstly, we would not have even bought the property if the township permits would have been shown a deficient structure setup. And secondly, the issue with the township in this property relates to continued use of the property. And if the property had the building prior to 2001, which it was, and it was occupied with temporary sleeping quarters, planning would have no issue. That being the case, we could have forced the former owner to obtain the correct permits himself based on evidence that he would have had at that time and properly permitted the property. Essentially, if the township would have had the various permits that the previous owner had to have, then we would not be here. Notwithstanding our legal position, we have been working with your township and related bodies to fully document this property for the benefit of your township and to avoid further conflict. Esteemed colleague from the Conservation Society, I don't know the exact name of it, is saying restore it back to its original use. Well, when I bought the property, it was already being used exactly the same way it's being used right now. The floor plate is slightly changed, but it's in the same place. So at the end of the day, there is no returning it back because it's been that way for years. I would bring forward the inconsistencies of the planning report created for this council meeting by your planning department. In the report, planning states that the building department, which I might again repeat, has no real records of what existed other than we took the time to submit to them. The records, in quotations, show the use being a barn only, close quotes. This statement and others made by the building department and people here are based on paper records and nor have been properly brought up to date by the township. We have presented to planning and building facts, not speculation. I will take 2 seconds off my sheet to just address the legal letter. The legal letter was a personal legal letter to stop trespassing on my property. It had nothing to do with the township and nothing to do with the people here. She trespasses on my property. I have the right to forbid that. And the letter stated that clearly. She's been harassing me and my family. That's Eva, my next door neighbor. And she continuously harasses us with her dogs and her trespassing on our property. That's what the legal letter was directed to, okay? And I was trying to stop the continued harassment. In the interest of time, I will list the facts that have been established beyond contestation. Each of these points are absolutely important, and I would ask that you consider both the individual points and the total implication of these points in your decision. Number one, at this point in time, we have applied, paid, and received permits for the 7 installations on our property. The reconstruction, again, is almost complete, and interim inspections have been done. Therefore, the only matter under consideration this time is the barn structure. I repeat, the only matter that forms the body of this request is the continued use of the barn structure. All other structures other than the barn are permitted and require no further intervention from planning or council. As such, there's no point in bringing up the past in further analysis or consideration in your decision. All these structures exist on this same property. There were 7 permits that we obtained. So this is all construction that's gone on and permitted. Number 2, in the process of obtaining these permits, we have been subjected to legal suits by your building enforcement person, 6 legal letters from your law firm, and have been unnecessarily forcefully delayed in the application and building permit process. Notwithstanding all these interactions, we have worked with your building department to complete their records of the project, including giving them detailed stamped construction drawings for every modification to the site, including the barn. Number 3, we have submitted absolute and irrefutable proofs, including aerial photographs, that all the structures existed on the same floor plates prior to 2001, which is when the zoning requirements were modified. There is no doubt that these structures existed on the same floor plates, and specifically the barn existed prior to 2001 and was being used and occupied in a similar manner to what my family does now. That is, intermittently, a few days a month. As such, we maintain we have the right for continued use, and we will defend that right. Number 4, we have shown beyond doubt that the barn structure has been upgraded to a hangar with accommodation, kitchen, and sleeping quarters prior to 2001, and again in 2012 with further electrical services installed through Hydro One. And these services remain at similar output levels. We have shown pictures of the work done on this property prior to our purchase, where it had plumbing, well water access, a septic system connected to the main system. None of this work could have been done without permits or involvement of the township. To claim otherwise would not be supportable in any third-party review. Number 5, I'm advised that the existing zoning allows bed and breakfasts. Not that we are operating a bed and breakfast, and I should mention the whole thing with the website from last year was just to support the farm accommodation. No one uses that property except my family or friends of my family. We would only be using this for family and friends, so the effect is negligible to the community beyond what is already allowed in certain places for bed and breakfasts. Number 6, the township has no information on previous permits issued prior to 2001. This fact is a liability of the township and not our liability. We have produced every document and every clearance required of us in the 4 years of the township's interest in this property. This means that there is no other information that the township can rely on in further proceedings, where while we can stress our factual information and affidavits from the many people that worked on the project as to the truthfulness of our position when we bought the property. Number 7, the property is unique, and so no decision made by council will create precedents. This affects no one outside my family. Bear in mind that we pay taxes and are an equal member of this community to all of you. So this decision should be made in what's best for all of us, including my family. Number 8, the property barn was used as an airplane hangar and mechanics residence prior to 2001. This is a fact. We have shown that the FCC would not certify an airplane on private property without regular multi-day on-premise inspection. I should mention, stopping here for a moment, that the gentleman that owned this property owned different types of planes. Something that was not mentioned. Prior to 2001, he owned an actual propeller type plane. You cannot fly those. After 2001, he had a glider, he had different things, but prior to 2001, he had an actual plane. You can't fly them without them being certified. That's the law. Okay? During such inspection, the mechanics would have not been allowed to leave the premises and would have had to stay overnight. I agree with you, a couple of nights, not the whole month, but he would have to stay because he wouldn't be able to leave the plane. This is not a professional airport. This is somebody's private house. These are facts, not speculation. We have many people that can attest to the presence of these critical installations, sleeping quarters, bathroom, kitchen, when we bought the building in 2017. Once again, these are facts, not speculations. Number 9, my family uses this property intermittently. We do not live full-time there. So there would be no disruption to the community, and frankly, no one would be affected in any way by a positive decision. Planning makes the comment at the end of the report, how will township staff know the length of stay for temporary residents? Our position is the property is used just for our family and friends. We maintain a family calendar website that shows who will use the property on any given weekend, which we can give the logins to council and they can see. Even if we decide to allow other people to use the property, we don't think policing oversight by the township is necessary, given the isolated nature of our property. We're 163 acres. Nobody can see us. We're at the end of a cul-de-sac. There is no other property like ours in the area. So why would the township even care how many family members of mine are on the property? Planning maintains that we will not support this request until I produce some evidence that the mechanics actually slept in the barn in 2001. This request is unattainable and unreasonable. We have tried to find someone who can attest to this fact, but seeing as this was over 25 years ago, we were unable to do so. Even if we would have found someone and relied on hearsay testimony, which is what we heard tonight, an affidavit, it wouldn't be considered reliable given the length of time and the fact that planning is limited as to what they will accept at this time, which is why it's going to council to allow our zoning request. Please understand that though you have a choice at what you may decide, my family and I do not. If you don't approve this application, we will be forced to proceed to Superior Court and to the Land Tribunal. And though this gentleman isn't a lawyer, we have many lawyers, over 100 of them. And we will fight the battle that we have been advised by many senior planners and lawyers that we will not only win, but we will seek and will receive from the township costs and damages. With the expensive time delays that we have been subjected to due to reorganizations of the township, our inability to get proper mortgage for the property at this time, during this time, the province's intent to create a higher density in this area, plus the lack of information that the township has, there seems to be no basis or reason for council not to approve this application. Bear in mind that the province is looking for development all over this area. Developers have taken some advantage. The negative press that the township will be subjected to from not approving the application will cost, including the lawsuit, will cost hundreds of thousands of dollars. And I don't think that this should be a decision that is subject to outside decision-making. Bear in mind that in a negative ruling from council, there's no instance where enforcement will destroy the barn because this barn existed prior to 2001. So the ultimate end goal, what is it of the council's ultimate end goal? The structure existed, so therefore it's going to be there. So really all we're talking about here is very limited occupancy. I'm going to switch to another subject. Most importantly, and this is the most important part of my presentation, is we are part of the community. We are not going anywhere. We employ 10 people to take care of the property, all from the area, and employ countless other people and businesses in the area. Our land is used by local farmers. We support, with our business services and the companies that we own, many other companies in the area, in Ontario and across Canada. I will note to you that my family investment banking company, Blue Star Equity, has been in Canada for over 45 years. We own many law firms, CA firms, tax firms, insurance firms, wealth managers, stock brokerages, and other companies in Ontario, Canada, and the US, with some that specialize in land disputes. We will make sure our voices are heard if council chooses to fight our request. We're an important member of your community, however. Personally, I'm the vice chair of the Peterborough Yes Foundation, a not-for-profit that services the underprivileged in your area. I'm on the board of a credit union and serve as the chair of a subcommittee. And I'm the consultant for many banks, all working in this area that service you. We are not outsiders making this request. Rather than spending all the time fighting a position that is in the big picture, not important, we should cooperate together to strengthen the greater community, as my family and I are here for the long term. So I thank you all. Merry Christmas and Happy Hanukkah.
Thank you, Roy. Other members of the public wishing to speak to the application today? One more thing. Okay, Jen.
I'm just going to say one more thing. Mr. Murad is saying that this luxury 5,000 square foot residence is only being temporarily used by his family, right? But you said If you go on the website right now, this very moment, type in Jane's Cottages, you will see that it's advertised as a luxury rental for over $4,000 a night.
All right, you want me to answer that?
Yeah.
I think it's.
Wait, guys.
I'm just, sorry,
mean,
that's all I wanted to say.
You're
I just want,
completely ridiculous.
Jane, just stop. Please stop. Please stop. Please stop. Please stop. We're going to maintain order. We're getting off track and we're becoming, right now, what we're considering, as I mentioned at the outlet, is a planning matter. Let's focus on a planning matter. Jane, with all due respect, I'm speaking. This is the meeting that we're running here and we're going to run it orderly. So there will be no more outbursts, please, and thank you. Thank you. Any other members of the public wishing to speak to the application? If not, seeing none, going once, going twice, we're just going to double check with online just to make sure. Nothing, Mr. Okay. That's it. We'll go to a discussion with regards to council at this point and consideration of the report. Councilor Byrne, a question or consideration of the report?
Through the chair, it was kind of a question of what's been said already. If I'm understanding this right, there was 7 permits issued and then 6 letters from controversy about, were any of the permits that were being discussed actually issued since you bought the property in 2017 for work that you've done?
Just with regards, we'll go to Kyle with regards to this. So just to be clear, there are many elements of development on the property. So with regards to the barn element of the property, there hasn't been issued permits for that because the zoning doesn't permit it. So you need the zoning in place to get the permits. So there's other elements of development on the property that are evidenced from the photos and other discussions that are required permits because they weren't achieved prior to the work being done. So Mr. Murad and his family have been working through with Kyle, but Kyle, maybe you'd like to speak to that directly.
Through you, Mayor, Councilor Byrne, that was about the summation. We have issued several permits there for accessory buildings, a pool, septic systems, everything that we can that meets applicable law, in this case being zoning, all other applicable law. The one permit that is outstanding that Mr. Murad has applied for, but we've rejected at this point because it does not meet applicable law being zoning, is the second dwelling. So everything else that we can issue, like any other permit, we review it under zoning, building code, everything else that applies, and we issued if we can. The accessory buildings did comply. The septic is a replacement, it complied. The pool, we issued that as well. So, so there are, not to get it convoluted, because we keep referring to the property and the building in question. The property does have permits issued of things that were built recently by Mr. Murad. He has applied for those. The engineering we're talking about is building code details, because we have engineered slabs that require sign off. I haven't been able to witness those slabs being constructed. So we are at a place where we're conducting inspections now, as of any other building. But right now, the key thing being this outstanding structure.
Other questions, member of council? Councilor Natchez.
Thank you, through you, Chair. I'm just confused in the fact that when you referenced the letter from the lawyer that was given to your neighbor for trespassing with her dogs, and then yet Mrs. Hunter, who does not live adjacent to you, has received a letter from your lawyer. If you can just clear that up for me?
I sent a letter to my neighbor to avoid her trespassing on the property. She comes on the property with her dogs. I have a lot of very small grandchildren that walk around the property. They're scared of the dogs. We've told her several times not to trespass on the property, but she feels that she owns the property. I believe because she was friends with the former owner. I don't know. We sent a legal letter to stop her from stepping on the property and stop harassing us with various things. All the people here are subject to the same sort of harassment. Okay? Bottom line is, that's all it was. Now, what she did, she sent somebody to the township, and I got a letter from the township's lawyer, no less, threatening me and my family and getting involved in a personal dispute between me and my neighbor. Our position is very simple. Township should not be involved unless they want to be in a dispute between me and my neighbor. If I want to sue her for trespassing, I have all my rights. If I want to make anything I want to do on my property, it's my right. It's not her right to use council and this township's legal department to come after me and my family.
Okay, thanks for that. I'll provide some clarity on this and just please, again, quiet in the public, please, quiet. So with regards to the letter in question, as was alluded to earlier, there was an element of the letter that didn't reference anything with regards to trespassing or whatnot. There was an isolated sentence or paragraph within the letter explicitly suggesting that there not be attending at a public meeting, which is a municipal issue. And so that was the response from the municipal lawyer, is that we do not feel comfortable with any suggestion that you should not be participating, that you are entitled to participate. So to be clear, but your comments should be made and directed towards the application and the planning matters at hand. And we are very deviating off of that. So we are not going to have a further discussion about any legal letters about property sanctity. We are discussing a planning matter. And it's not a personal infighting discussion about who did what to whom. We're talking about a planning matter, and we've heard a significant amount of comments to that effect. And now council will be considering what to do moving forward, just to be clear. Okay? Council, other questions with regards to the planning application and consideration of the report? Seeing none. Very good. So my brief commentary on the report is that there's been a lot speculated and a lot said. With regards to the recommendations the staff has before us, there are two. One, that we receive all verbal and written comments received at the public meeting. The second is that council not support the approval of the zoning bylaw to permit a second single detached dwelling on the property of 401 Elgar Drive because the amendment does not conform with the Oak Ridges Moraine Conservation Plan, the Peterborough County Official Plan, and the Township of Cavan Monaghan Official Plan. You will notice that the Township of Cavan Monaghan is only one part of the planning documentations that are under subject here. There are two others beyond our jurisdiction that this also does not conform to. So that's just the status, that's the report. Would any member of council like to move any of the recommendations or have an alternative recommendation for council consideration? If not, we're looking for a mover and a second to the two recommendations. Moving those two recommendations, Councilor Byrne. Seconder for those two recommendations, Deputy Mayor Huntley. Voting, all in favor. That is approved. With regards to that, we now need a resolution to close the public meeting. Moved by Councilor Byrne, seconded by Councilor Natchop. All in favor? That is approved. Next on the item 9.1, staff recognition. We'll let the people just file out for a second, Wayne, if you don't mind, because I don't want to waste a minute of drawing attention to this. Yes, you did. So if we can just move out of the chamber and just avoid further discussion, we're got to move forward with the meeting. Sorry, guys. Thank you. Okay, we're moving down. Eva, take your time. There's no rush. So we have a very distinguished staff recognition component on the agenda today, and it's our Director of Public Works, Mr. Wayne Hancock. 15 years of service. It feels like just a glimmer or just a moment ago, but Wayne has dedicated himself to the township for, like, as I said, 15 years of service, and we're still enjoying his service and all that he brings to the community, which is a ton of experience and expertise, and not just public works, but all of the water, wastewater navigation that we've had to do as a community. And we would not be in the good position that we are in now without those years and years of service. So Wayne, it is my pleasure to present you with this certificate and congratulate you on 15 years of service to the municipality. I'm sure you'll get a few letters, Wayne, no doubt. All right, next item on the agenda, not is we've just done staff recognition. Now we have 10.1 Randy Smith with regards to parking spaces. Randy, come on forward.
I'm glad all those people weren't here to fight me. Just like you said. Uh, yeah, I'm looking around going, what the heck? Mr. Mayor, councilors, thank you very much for listening to me today. I know you've obviously had a busy day here, so I'll just be pretty quick. I don't think I'll need the 10 minutes. And I'm basically here for hat in hand to ask for a price reduction on the sale of the parking areas at Union Street. This started, I think, almost 4 years ago now, something like that. So it's been going on. So just to refresh you, or maybe you already know everything, it's used to be the gas station. It was all one property. It's been now severed into parking spots and I guess a small building lot, or two separate areas. So one area is for the post office, so they can do an expansion. And before I go on, I just want to say I realize that the post office is more important than me, for a better way of saying it. The mail must get out and whatnot. However, it's in my opinion, and it's a win-win situation for these parking spots. If you can notice on the plan, it's the narrow strip. When I bought the property, it was actually power sale. I did not get a survey. I actually thought that was my property and just found out through getting these surveys that, okay, I don't own it. So I guess I have to buy it now. We've been parking, or tenants have been parking there. I've been telling them I don't own it, but they continue to park there. So thank you for not giving them tickets, I guess. And then today I was just thinking, because when I bought the building, the gas station was still there and tenants were always parking there. And I'm guessing that they've probably been parking there since the invention of the automobile, along the side of the building, because that's where the access is to the units. So I don't like having to pay all the money to purchase it. But it's a win-win situation, in my opinion, for the town and for my building. It'll keep cars off the street and whatnot. I guess whenever this started, unfortunately, we didn't get a price on it till the very end, which I realize that's just part of the procedure. I didn't have much input in anything. The building lot, or the larger parcel, is I mean 2.5 times the size. So I'm not sure financially how that was worked out. I have no idea. I just know that it was way over what our budget thought it would be for some additional parking spaces. And then I won't go on all the things that have for me to incur the extra costs, other than the cherry on top, which we just found out, is my accountant told me, because it's a residential transaction, we cannot get the HST back. So now that was added on top. Like, as a business, if I could get the HST back, well, then it's almost a non-factor, but unfortunately that's not the case. So I guess I'm here hoping that you could put your place in my place and find if we can get a little reduction.
Thanks for that, Randy. So just to clarify, or to summarize before, and then council can have discussion. So with the HST reduction, by my calculation, that'd be about 95,700 be the purchase price. And then you have your legal separate. That's a 13% HST reduction. Is that kind of what the number you had in mind? I just want to make sure that the reduction in we're trying to get that final number, because we had to, just to answer your question as well, it was insinuous, we had a private appraisal done. It's not a township valuation. It's just, we contracted that out so that it's a neutral, unbiased document and number that we get to. So your request for is in essence a 13%. We're not exempt from it either. So the 13% reduction would be analogous to that 95.7 in my calculation. Is that what you had in mind with regards to your request?
Yeah. well, I guess nobody's here now, so. Yeah, I'm not sure where you're getting the 95.7 from, but I've got, I think this is from the township. I've got, the total cost is 131,831. And then prior to, yeah, in the HST. Yeah, I'm not sure where you're getting the 95 from.
So so the valuation was 110, prior to HST. So that was what the appraisal of the property was for. So because we don't waive HST, it's a municipality, it's not our revenue stream. The only thing we could do analogous to that would be reduce the 110 by 13%. And then you'd still have to pay HST on top of that, obviously, because we can't exempt you from it, right? So that's sort of so when I apply a 13% to 110, I get 14.3. I take that off 110, I get to 95.7. So just for clarification, and then obviously the legal fees are separate from that, but so there would be HST on top of that. So it's not an all-in 110 price. We're reducing it by the 13. You're asking for consideration to reduce the HST, which gets us to 95. Then you add the HST and all this stuff on top of it. And I can't tell you what the total number is, but we're just trying to get a clarity on the purchase price, and all the accoutrements after the fact are kind of up to the different bodies. Is that clear?
I think so. Yeah, I think what you're saying is, it was 110, but you're going to reduce the price. So it goes back up to 110 with the HST. Is that, and you're saying that's what I'm requesting? Okay, we're on the same page. Yeah.
Okay, questions, members of council. Councilor Byrne.
Through the chair, Randy, I'm hoping I got this right, but this is fairly strategic for you. Without this parcel of land, you're basically legally landlocked to your apartment. But that being said, for future consideration, you're not actually buying any of the Williams Garage property, if I got it right. You're buying a sliver of land that the township owned, and your parking has been on the Williams Garage for years. And that's not going to be your property moving forward. It's still going to be a different parcel of land, if I'm correct.
Yes, well, I think they own that too. I believe. I don't know for sure. Some, because it's all the same.
Yeah, Ms. Ellis, would you like to just clarify? Oh, sorry, that's still me. Still me.
Through you, Mayor Graham, to members of council. So the property is in odd shape currently that the township owns. So through the reference plan, it's split into two. The square parcel that's going to be added to the post office, where you can see the dark square there, the former Williams Garage building. The long strip will go to Randy. So that was all part and parcel of one property originally, and through the reference plan that the township has done, it has been split into two to be sold to two different partners. With the sale of the property to Randy, it will be merged on title, I would think, with your apartment building to create one parcel. That strip will be able to be used for parking. There is lot frontage on King Street right now for the apartment building itself. Through you, Mayor Graham, so to Mr. Smith. So you have lot frontage already. You're not landlocked. You have frontage on a public road. Yes, but this strip will provide much easier access to the parking area. And the parking area will be on that strip and on Mr. Smith's property only. What Canada Post ultimately does with theirs, we will see through future approvals.
Got it. Clear. Other questions, members of council? Deputy Mayor?
It's through you, Chair. I guess not really a question, more of a comment. I guess, the property was assessed at the 110, I suppose it was, but I mean, this really is a single purpose piece of strip of land. It's not going to be used for anything other than parking. So I can't picture this, I can't even picture it being valued at that high, to be honest with you. So I'm fully in support of reducing the cost down to the 97.5 for Randy if we get there.
Any other questions? Ms. Hurley.
Just for clarification, so yes, the property was evaluated by an independent appraiser for 110,000. The additional costs as per our disposition of land are to share the costs regarding the severance and the legal costs. So that equates to $6,165. So just want to make it clear that if your reduction, if you're considering reducing the 110, however you wish to do so, whatever you're asking, Mr. Smith, then the other additional costs are still apply. Okay, thank you.
Yeah, the intention, so the recommendation is that we receive the delegation from Randy and direct staff to work with Mr. Smith. We just had to clarify some of the direction as to work out an agreement with the reduced amount or proceed with the appraised amount. So that's kind of really what we're looking for in that prediction. So seeing no other questions, if someone like to make a motion, we can then consider the motion. So that would be, do you want to clarify the motion just because we need a little bit more details? Are you about the reduced amount or otherwise? So just for clarification, then we're looking for council to receive the delegation and for information and direct staff to work with Mr. Smith at the revised appraisal amount less the HST from the previous appraisal. Is that how you'd like it worded, Tim? Is that clear? Ms. Pope? Sound good?
Right, and sorry, just to, for clarification, I'm just wondering about the additional cost that the CAO has mentioned. So is that's a separate issue? Okay, so yes, the $110,000 less the 13% HST to be part of the motion.
That's the motion. Councilor Natoff, look for a seconder for the motion. Deputy Mayor Huntley, all in favor? That is approved. Thank you very much, Randy. Thanks for coming.
Thank you. Really appreciate it. I can go buy a pizza now.
All right, excellent. Thank you, members of council. Moving on to next item is 11, the minutes of the regular meeting held December 1st. And a mover and a seconder for those meetings to approve them as presented, moved by Councilor Burns, seconded by Councilor Natchoff. All in favor? That is approved. Next, we have the minutes from committee and boards, accessibility advisory committee minutes from September 18th and October 30th, approved as presented, moved by Councilor Byrne, seconded by Councilor Edgerton. All in favor? Those are approved. We are in the reports section of today's meeting. Ms. Pope, tax collection policy update.
Thank you, Mayor. Through you to all of council. This is an administrative update on our property tax collection policy. Basically, in summary, since prior to even my arrival in 2008, we have had a recurring monthly program that only spanned 11 months. And in December, there was no payment. It often causes confusion when someone's coming to sign up because usually a monthly program is every single month. In addition to that, the TD Canada Trust also began changing their risk matrix with Canada Mortgage Housing Corporation. And they're actually no longer submitting on behalf of their mortgages, and people are paying directly. And with a lot of online opportunities, things have changed. And so there's the opportunity for people to come and sign up with our program, which is fantastic. But it's confusing when it's 11 months and not 12, and we would like to change that. We do have software that does allow that. And as an example, if you had a $3,000 tax bill, currently divided over 11 months, it would be $273 per month. If it's divided over 12 months, it would be $250 a month. So it's not an increase, it's actually a decrease, but it's not a decrease in taxation, it's just a decrease in payments. And because when we send out the final tax bills in July annually, and there's less months to divide it over, people often will call the office and ask why their taxes have gone up. Well, their taxes have not gone up. It's just we have one less month to take those funds over. So still keeping with the same intake program before the interim, before the final, just having it more equal. So it's 6 months each time. It does affect our bylaws for our property taxes as well. And we just want to make sure that everything was clear right from the get-go before we walk into 2026 to be able to offer this program. Anyone that's currently on the program would receive it with their normal letter that they get in December. So we're going to advise them if council were to approve this today. We have approximately 18% of our population that are currently on that program. And so they will get a letter where it's not cheaper, but because it's spread over an extra month, the monthly withdrawal would be a little bit less. So that's kind of the messaging. We'll make sure it gets out to the residents that are currently using it. And anybody new that would sign up would come on to a 12-month program as usual. This is the regular monthly program that has no arrears. You have to qualify for that. If you're in arrears, it's already 12 months and it charges interest, but this is not the one we're talking about. This is the one that does not charge interest. It's 12 months a year. Someone has to be in good standing to be on it. These are great property taxpayers, And we just want to match the program to 12 months instead of 11.
Yep, so just for reiteration, so this is literally just changing from an 11-month cycle to a 12-month cycle. That's it, and all the people that are the 18% or so of the population that do it will be receiving information about that adjustment moving forward. So they maybe haven't been seeing or have been feeling as though they're making a December payment, but in essence, they really haven't. So there will be a payment extracted from the account, but it'll be at a lesser amount, yeah, for next year. Yeah, exactly, right. Okay. Thanks for clarification. We'll go to Councilor Byrne and then Deputy Mayor Huntley.
Through the chair to Kimberly, two things. There's no additional cost to the people that have to migrate from this to the other, whatever they pick for the other. The other thing, what's 18% represent in a real number? I hate just percentages.
It's approximately 800.
Mayor?
Through you, Chair. I think it's a great program, Kimberly, but I guess my question is there a convenience fee associated with this, or is it a free program for anybody who wants to sign up?
So through our user fees and charges bylaw, when you're signing up with a mortgage and it's coming on board and there's a pre-authorized program, there is a fee for that. And that's part of the user fees and charges bylaw. This program with the municipality, we don't charge for. So we enroll them in our program. It's the arrears program where they get charged penalty and interest because they're behind. So no, and you would see that in user fees if we brought it up.
Okay. Two recommendations. One, that council receive this report as an update and that council approves bylaw number 2025-61 being a bylaw to adopt a property tax collection policy. Moved by Councilor Burns, second by Councilor Natchez. All in favor? That is approved. Good discussion. Thank you, Ms. Pope. Kyle Phillips, noise bylaw review. Mr. Phillips. Oh, sorry.
Thank you, Mayor. Through you to council. The report before you is in regards to the delegation made to council on August 11 pertaining to noise concerns in the downtown core. The delegation sought to have the music exemption removed from the municipal noise bylaw. Council then directed staff to do a review of the noise bylaw. As you can see, we did quite a thorough review of many of the areas around us, other similar municipalities that have a similar downtown core towers where the main concern is. We also looked at a number of ones that were a little dissimilar, bigger cities to see how they're dealing with noise. We spoke to a few of the bylaw officers that would return our call with regards to this. We also spoke to the Peterborough Police, who our original bylaw is drafted after. The main outcome of that is that our bylaw is still consistent with most of the municipalities across our review, across Ontario. The noise bylaw is not an easy bylaw to enforce, to administer. It's very subjective. There's many different examples of situations you can get into. Our bylaw, like most of the other ones, that are working well, and it is working well throughout the township. It's based on the idea of a noise likely to disturb. So as you can see in here, we looked again at decibel monitoring equipment, all that. That gets a little convoluted because we have to set decibel limits, and then decibels are very much affected by weather, building types, acoustics, what direction the stuff's going. Staff don't believe that's a route we want to go down because the bylaw is working well. It's really just this downtown core issue where we have the exemption for music. So just to give you an idea of why the recommendation is the way it is when an officer attends, if we receive a complaint with regards to any noise through the township, an officer attends, and that can be a Peterborough police officer or a bylaw enforcement officer. What they're going to do is take a look at what the issue is, and they basically have three options. If the attending officer sees, hears, what's going on, they can make a judgment call that this is a noise likely to disturb if it seems very, don't want to use the term excessive because there's other implications to that. But if it's something that they say, yes, this is a noise likely to disturb for sure, they'll lay a charge. On the other end of that, they could say, no, this isn't the type of thing. This is maybe frivolous. Who knows why they call? Maybe it's neighbors disputing. They won't lay a charge. There's also an area in between where, because noise is so nuanced, it could be something that is a long-term thing that they can't tell right that day if that's a noise, if they can't make a determination. So what they can do is say, we'll lay a charge, but the person who's being disturbed by this noise must attend court to relay to the judge of why that noise is beyond the threshold likely to disturb. So that's how most of our noise complaints go. So staff's recommendation is that we remove the exemption and let each instance resolve itself by the officers attending, and to be able to give them the opportunity to make a judgment call there. If we don't, there could be, not that anybody's used it in the past, but if we just exempt it, there is no limit to it. So it really restricts officers in that regard. That being said, noise is very, as I said earlier, very hard to regulate. It's a very nuanced thing, but the recommendation before you is that council amend the noise bylaw number 2022-21 to remove the music exemption in section 4. Thank you.
Thanks, Kyle. So just to reiterate again, so I guess just for maybe it's my own clarification. So removing the exemption in no way means there's a moratorium on sound, noise, music, or otherwise in the downtown. It just means that instead of having this kind of carte blanche exemption or maybe open-ended exemption, that it really bestows on the officer the ability to interpret based on their practice and knowledge, the likeliness to disturb criteria. And then if or certain noises be deemed likely to disturb, they would issue a charge and then it would proceed to court. If they weren't, they have that jurisdiction to sort of say, nope, we don't believe this is likely, this doesn't meet a threshold, so it's not. So I guess that's just sort of an understanding of where we go. So removing the exemption doesn't mean that there's a moratorium. It just means that it's an officer's, kind of due diligence to go forward and then make their jurisdictional call about that. Versus in the kind of under the exemption, it's kind of, we don't afford that ability to make those inroads out to a degree. Is that correct?
Through you, Mayor, to you, that's exactly correct. It gives the ability to enforce that. So removing it doesn't mean that there's going to be charges laid in any of the regards of what's going on down there. It just gives that ability. And to give a good example from the Peterborough Police, obviously they have a much larger downtown core, so they have the same issues on a bigger scale. What they'll do, because there's bars down there that have live music, they're playing, there's all sorts of music that goes on down there. They'll attend and if it seems beyond what's reasonable for a bar, if there's a band playing and you can't hold a conversation there because it's so loud, they will then, mediation is always in bylaw, and that's mainly a bylaw. It's always their first option. So they'll give them a warning and say, this is very loud. This is going to be excessive. I'm going to use the term to most residents here. Please turn it down. If they attend again and it's that loud again, they will lay a charge. But if they show up to a commercial establishment that's zoned to be downtown, and we have some of those now where there is going to be a likelihood of music being generated just by their sheer use, they're going to show up and say, is this reasonable? So if you can have a conversation, but there's a band playing because it's a licensed and zoned pub or bar where that's expected, they're not going to lay a charge there if it's within reasonability. That's the main example that I think lends itself to this. Thanks.
Thank you for that. Questions? Councilor Nacho.
Thank you. Through you, Chair. Kyle, would you be able, just off the top of your head, tell me how many times that we've actually had it so that someone's made this complaint and then had to show up at court to represent themselves in this circumstance?
Through you, Mayor, to Councillor Natchoff. As far as I know, it'd be 0, but I couldn't speak it because most of the Peterborough Police, they're after hours, they're parties, they're all kinds of things that typically happen after hours. They may have had that, not to the best of my knowledge. We don't get a lot of noise complaints here. They are generally parties or they're, ATVs, stuff like that are at certain times. I'm not sure that we have any. This situation's kind of unique. So I would say the answer is, I'm not sure, but I think it's 0.
Deputy Mayor?
Through you, Chair, I guess, the exception isn't like a carte blanche exception. It's to a certain time frame, right? So if this is after hours, just like you're describing, the Peterborough Police would be attending, the same would apply now with it in place today, right? Because it would be in after hours and it would be up their discretion. So I'm not sure what we're solving here.
Through you, Mayor, to Deputy Mayor Huntley. That's correct. So after those time limits, yeah, it's, you're right, it's not carte blanche, but through the day, there is an idea there that it's unlimited because now it's completely exempt, so there is no judgment call to be made. But you're correct in what you're saying about the time limit sales.
Okay. So there's not, the recommendation is to remove the exemption, but also to use Mr. Phillips' own words, it seems to be working fairly well. So there's not a ton of, this is one of those nuanced decisions that council really has to make. So the recommendation is to remove the music, but like I said, we can keep things as is. If we are keeping the exemption as it is there's no need to bring back the bylaw. There's no other language changes or anything to extend. It's just a renewal sort of thing. Okay, fair enough. How would council like to proceed? Deputy Mayor.
Through you, Chair, I don't see the need to make a change. I'm happy with, I think it's option 1. So I don't know what the nuance is. Do we just vote this down or do we put this on the table and see what happens? Like, how do you play it out?
I think we would simply receive the report for information. I mean, the bylaw is as it exists now. Is there a need to renew it or reinforce the fact that the bylaw is as it stands, Ms. Page?
Through Mayor Graham, to yourself and the rest of council, I think it would be clearer to the audience as well as the staff if you do say that council not support the amendment to the noise bylaw to remove that.
That'll be the motion, Deputy Mayor. All right, seconder for that motion. Yep. Councilor Byrne will be the seconder. All in favor? We're maintaining the just for clarification, we're maintaining the exemption as it is today. All in favor? That is approved. Thank you. Good discussion. Thank you, Mr. Phillips. Next on the item, we have disposition of land 1 Union Street. Ms. Ayotte.
Thank you, Mayor. The report before council is ECD 2025-16, disposition of land 1 Union Street, with the recommendation that council receive the report for information regarding the disposition of the retained portion of 1 Union to Canada Post, identified as Part 2, 45R-17792, being part of the lands described in PIN number 28012-0409 LT. This is the other portion of the land that Mr. Smith was speaking to. So this has been kind of on the docket for a bit of time. So we're finally closing the loop on it.
Yep, this has been many years coming. Questions with regards to the report with 1 Union? I don't see any. The only thing that was discussed at their previous budget meeting that I would add, in addition to the recommendation in the report, the similar motion that we had for the previous disposition of land consideration, that council direct the budget committee to utilize the net proceeds from the sale of this property to reduce the 2026 tax levy, and that the utilization be reflected in the next special budget meeting. That's a motion moved by council. So both of those recommendations moved by Councilor Byrne, seconded by Councilor Edgerton. All in favor? Those are approved. Thank you, council. Thank you, Bridget. Next on the item is, I believe, 13.4, corporate services, community safety, wellbeing. Mark, there you are.
For you, Mayor Graham, to council, before you is report corporate services 2025-13, the community safety and wellbeing plan 2025 update. The recommendation is that council receive the report and the update for information. Just as an overview, municipalities are required to prepare and adopt by resolution a community safety and wellbeing plan under Section 248 of the Community Safety and Policing Act. These plans must identify social and structural risk factors in the municipality that lead to crime, victimization, addiction, drug overdose, and severe mental health issues. Council adopted on June 20th, 2022, a joint community safety and wellbeing plan with the townships of Asphodel, Norwood, and Otombi, South Monaghan. Since then, staff have provided updates noting the progress on the plan, with the last one being in February of 2025. Just to give you a brief overview of some of the achievements of this, that staff have done, the township has continued to work towards some of the goals to reduce the risk factors identified in the plan, particularly providing housing support and reducing isolation in the community. That includes working with many community groups in the township, including Community Care and the Millbrook and District Food Share to help them deliver the programs. Township also runs a number of programs through Cavan Monaghan Libraries and the CMCCs to bring the community together and break socialization and make certain social supports are available to residents of the township. And staff will continue to support these programs and work towards the goal of the Community Safety Wellbeing Plan throughout this year.
Thank you, Mark. Nice to see we're making progress and moving forward with our legislative requirement for this, but the community is doing some great work. And I know that it's actually on the county agenda coming up that I think they're looking to mirror ours where they, to those municipalities that haven't completed the component yet. Questions, members of council? Councilor Byrne.
Through the chair to Mark, people ask me a lot, and I don't know if this is the right venue for this discussion, but the number of house break and enters in the community over the last several years, does that fall anywhere in this preview of how we're looking after the residents?
No, that's a policing matter. This is community safety and well-being. It's completely separate. Other questions? If not, the recommendation is that council receive report corporate services 2025-13 community safety and well-being plan 2025 update for information. Moved by Councilor Nachow, second by Deputy Mayor Huntley. All in favor? That is approved. Next, thank you, Mark, for that report. Next, Millbrook and District Medical Center Board, Ms. Hurley.
Through you, Chair, to Council, the recommendations before you for this council report is that council support the Township of Cavan Monaghan taking governance control for the Millbrook and District Medical Center. And that should council approve recommendation 1, that the council determine the new board of directors of the Millbrook and District Medical Center be comprised of the following: an ex officio directors, mayor of the Township of Cavan Monaghan, 1 councillor for the Township of Cavan Monaghan, and 2 township staff, the treasurer and a director. And the third recommendation is that should council approve recommendation 2, that council authorize the chief administrative officer to execute such corporate documents as necessary to elect such individuals as the director of the Millbrook and District Medical Center, and that otherwise bring the corporation into compliance with the applicable corporate law. So this is a little bit of a detailed document. It has taken some time to basically take a look at what we could do to continue with the medical center. This is the best way we can do it. It is a little bit tricky with regards to how we do that by taking a not-for-profit corporation, changing it to become still a not-for-profit corporation, but under the corporation of the Township of Cavan Monaghan. So there are a little bit of steps that we have to do this, but it has, like I said, it's taken some time, but we're very pleased to present this before you today.
Yeah, and having served on the medical board during this process, it has been a ton of work to get to this position and figure out how to move forward and also get updates to all the historical documentation that a not-for-profit corporation requires has been a lion's share of the work. So I thank Ms. Hurley and some members of the legal team for all the hard work on that to get it to above board. But the idea is that the council positions will, be discernible based on that. They want to exist beyond just this term of council. Obviously, we're in the last year, moving into the last year of this term of council. So we want to make sure that it stays and that the mayor can be appointed and then an additional member can serve. And then staff can obviously keep on top of the operations and functionality and the existing contracts that are in place now so that we can continue the smooth operation and maintain that medical center moving forward to serve the community. So been a lot of work to get here. So thank you, Ms. Hurley, for all that hard work. But questions with regards to the report? Councilor Byrne.
Through the chair to Yvette, and then I'm just wondering, and you kind of addressed it, but that transition from the mayor of the day as elections happen forward, will there be a transition period built in? or will it just be the election date?
Charlie can speak to that.
Through you, Mayor, to Councillor Byrne. So what happens, basically, the next step, should you support this, is the current members will resign, leaving only the corporation of the Township of Cavan-Monaghan left as the director. At that time, with the support, then we would automatically move forward as per the recommendation number 2 of who would sit on that committee at that time. So you're sort of dealing with corporate law, but we're also dealing with municipal law. So there's a little bit of an overlap how you do that. But once they resign, the only one standing basically is the corporation of the Township of Cavan-Monaghan. And at that time, they would automatically, your new board would be established at that time.
Just for clarification, I think Jerry was asking about Councilor Byrne was asking about the transition during elections, like the handoff, like, so when there will, like, the December will be the first meeting for the next council, so that mayor will then take the reins of that position kind of immediately. Tell me if I'm wrong, Councilor Byrne, but I think it was more term to term, not so much this immediate transition, but like, no, in 4-year cycles, how is that going to be managed? Because that's, I think, a catalyst for the staff positions to be there for that continuity and that they can bring the new members up to speed.
You are correct, Mayor. So basically, it's about the positions, not, so whomever comes in next year would automatically have the seating in that position.
But there'll be an overlap. Okay. Yeah.
Well, it happens with the election, right? So whoever the mayor is at the new election, then that mayor will then sit on that seat. It's not really an overlap. It's just that is a duty as per what we're putting in place today.
Add it to the list. Questions with regards to recommendation? If not, we can take a mover in a second for those 3 recommendations. And again, thanks to Yvette and staff for all the work. It's been a long 2 years of a lot of really inside baseball bureaucratic stuff when it comes to not-for-profit work, and it's been a ton of work. So, and I also have to thank the board for their patience during this, and they're very excited to move forward. So with that, look for a mover and a seconder for those 3 recommendations. Moved by Councillor Edgerton, seconded by Councillor Natchoff. All in favor? Those are approved. Thank you very much. Good discussion. Next is the CAO report, capital status. Ms. Hurley.
Through you, Mr. Mayor, to council. The report is before you. If you have any questions, please, we're here to answer any questions that you have. I do have one clarification that I'd like to mention. At the last council meeting, there's a statement regarding site plan control. So therefore, just for clarification on that pertaining to site plan control, Bill 109, More Homes for Better Act in 2022 mandated that all municipalities delegate the approval authority from council to staff when it comes to site plan control. I think there was a misunderstanding on the question, and I just wanted to clarify that because it's very important that council understands that. Thank you.
Thank you, Ms. Hurley. Questions with regards to the CAO capital report? Councillor Byrne.
Through the chair to Yvette, on page 146, the line about the repeater communication upgrades, we're running out of 2025. Is there an estimation that it'll meet the deadline, or where are we at with that?
Through you, I can only say that that's the information I received at this time, but I can certainly follow up and get an updated. But as of right now, that's what that we have from our chief at this moment.
Yeah, maybe we can ask the chief at the next budget meeting in January to speak to that project as well. Perfect. Seeing no other questions, we'll look for a mover and a seconder to receive that capital status report for information. Moved by Councillor Natchoff, seconded by Deputy Mayor Huntley. All in favor? That is approved. Council committee verbal reports. Any committees still in action for the Councillor Friend?
Through the chair, I'd just like to mention to the public the chance to go over to Lindsay to the Kawartha Lakes Conservation property. They're running a program this winter. The walking, talking forest lit up at night. And if you go online, there's a chance to use the advantage of free parking downtown Lindsay to get out to the location at Kenry Park.
Thank you, Councillor Byrne. We have a library board meeting tomorrow night, so more update, but just a further discussion again of from the last previous meeting is mostly around the budget and things like that and the adjustments that council's already heard from last week's meeting. But also just wanted to make note and thank, obviously I have to thank a number of people. So we, Councilor Byrne, Councilor Nashoff and I were able to attend the firefighter recognition awards with a number of individuals receiving their accommodations and different acknowledgements throughout that. It's a great event. And a great dinner held by the Legion, so we thank you for that. I also want to thank the fire and all the members of the community who participated in the annual Santa Claus Parade. It was a big hit on the weekend. I think we had upwards of 27 different floats, if I'm not mistaken, which is a great and a great experience and a great event. And there was a lot of members of the community out there for that, so that was also excellent. So, with that, can we get a motion to receive those committee updates? Councilor Natchoff and seconded by Councilor Byrne. All in favor? That is approved. Just want to make sure I do everything right for this page. There is no general business. Oh, sorry, wait, I'm missing one page here. There is no general business. There is one item as correspondence for information. As I mentioned in the social media shared video, that we did receive this letter on Friday with regards to some just basic sort of beginning information that there will be an extension with regards to the Shorelines operations at the Kawartha Downs beyond the previously mentioned March 31st deadline. So, as I did in the video, I want to thank obviously members of council for our letters and work on advocacy in the background with regards to the announcement that we previously heard. And also want to thank MPP Scott, members of the union, and also members from the Kawartha Downs about the collective advocacy that went into what is a great announcement for the community and for a lot of workers at Kawartha Downs moving forward. And nice to have it before the holidays. So that's just sharing that information with the public, but more details are still being worked out. So we want to make sure we stay in our lane, but there will be more of the announcements coming in the new year, no doubt. So just receiving this letter from Ontario Lottery Gaming Corp regarding the continuation. Looking for a motion to receive the letter, moved by Councilor Byrne, second by Councilor Natchoff. All in favor? That is approved. Oh, hitting the mic. There is no correspondence for action, so we have our bylaws. That bylaw number 2025-58 being a bylaw authorizing the temporary borrowing of funds to offset the current expenditures of the Township of Cavan-Monaghan, and bylaw number 2025-59 to provide for the levy and collection of 2026 interim realty taxes and penalties for non-payment thereof, and bylaw number 2025-60 zoning bylaw amendment ZBA-08-25 402 Thorn Drive, and bylaw number 2025-61 being a bylaw adopt a property tax collection policy, be read a first, second, third time and passed this 15th day of December, signed by the mayor and the clerk, and the corporate seal attached thereto. Can I get a mover for the bylaw? Moved by Councilor Byrne, seconded by Councilor Edgerton. All in favor? That is approved. There is no unfinished business. Any notices of motion? Seeing none. The confirming bylaw, that bylaw number 2025-62 being a bylaw to confirm the proceedings of the meeting held December 15th, be read a first, second, third time and passed this 15th day of December, signed by the mayor and the clerk, and the corporate seal attached thereto. Moved by Councilor Natchoff and seconded by Councilor Byrne. All in favor? That is approved. Lastly, motion to adjourn today's meeting. Moved by Deputy Mayor Huntley, seconded by Councilor Edgerton. All in favor? That is approved. This is the last council meeting before the new year, so we want to wish everyone a happy holidays and a Merry Christmas and the best of the new year. But also there's a number of upcoming events. As I mentioned, the Cavan-Monaghan Public Library Board meeting is scheduled for tomorrow night at 7 p.m. at the Millbrook Branch. The Accessibility Advisory Committee is meeting on Thursday, December 18th at 1:30 p.m. Our subsequent next budget meeting and the next council meeting is the special budget meeting held Thursday, January 15th. And we also have the evening meeting that's open to the public with regards to the budget on the same day, Thursday, January 15th, starting at 5 p.m. in the chamber. Thank you very much. And again, best of the holidays to everyone in the township.